There are two ways to remove Auntie Bev. If Auntie Bev has a history with one of the parties. Remember the text messages. Oh, you mean Auntie Bev? She uses the beach house. She doesn't like me and she is mean to me is not enough of a reason to get a judge to recuse herself. You need more. Well, hello everybody, and welcome back to Buckle Up, It's the Law. Today we're going to be talking about how to remove a judge from the bench. Now, naturally, a lot of you have been asking questions. Beverly Cannoni is so corrupt, and there is so much corruption going on in the Karen Reed case, and I'm so appalled with this judge. Is there nothing that can be done? Can we do something? Is there something that we can do? Well, folks, I'm here to tell you that yes, there is something that can be done, and yes, there is something that we can do, both the defense lawyers in this case and us, the public. So let's talk about it, shall we? First and foremost, there are two ways to remove a judge from a case. The first is removal of the judge entirely from the bench. That way, the judge will no longer be able to be an active judge on any case anywhere ever again. They're done. They're essentially forced into forceful retirement. And this is not including retirement by age. You know, when Auntie Bev reaches age 70, she'll automatically retire. I'm not talking about that. I'm talking about forceful removals from the bench. And number two, we're going to talk about recusals. What are recusals? What do they mean? How do they work? And can it work here in this case? So let's start with the simple one. How do you remove a judge from the bench? I mean, let's say a judge has been caught actively engaging in corruption, accepting bribes in exchange for rulings. And that one is fairly straightforward. There are committees that allow for judges to be removed. For instance, in the case of federal judges, and the district court judges, appeals court judges, and Supreme Court justices, the Constitution outlines the primary mechanism, impeaching the judge. Article 2, Section 4 allows for removal of civil officers, which includes judges for treason, bribery, or other high crimes and misdemeanors. The process starts in the House of Representatives, where a majority vote is needed in order to impeach. Then, the Senate holds a trial, requiring a 2/3 vote to convict in order to remove the judge. In the last 250 years, when the United States first came about, there have only been 15 instances where a judge has been brought before the House of Representatives and impeached, and then only 8 of those were removed. So about 50% of the judges that have ever been impeached have actually been removed in federal courts. The most recent being in 2010 for corruption. That was G. Thomas Porteous Jr. Now, in the case of Auntie Bev, since she's not a federal judge, she is a state judge, but she was not elected, she was appointed. What is the procedure there? For state judges, methods vary. Most states use impeachment, similar to the federal process, which is also handled by the legislature. Some states, like California, also allow for something called recall elections, where voters can remove a judge. Think of the 2018 recall of Judge Aaron Persky over a controversial sentencing decision that they had. Others rely on judicial conduct commissions, such as the SJC in Massachusetts, and the Judicial Qualifications Commission, the JQC in Georgia. It's the same entity, different name, because it's a different state. So what would we have to do in the case of Auntie Bev? Let's start there. We would have to go to the House of Representatives and ask that they impeach Auntie Bev, and then the Senate would vote to remove her from office. If the House of Representatives do end up impeaching her, and the Senate removes her from office, she will no longer be able to preside over not just this case, she would not be able to preside over any cases ever for the rest of her life. But in order to do that, as we all know, there has been a lot of corruption going on in the Karen Reed case, we have to show proof. We would need receipts that Auntie Bev has conducted corruption. You are completely not permitted to base your accusations based on assumptions, conjecture, and speculation. You would have to bring testimony. You would have to bring receipts as to what the judge has done and why they should be removed. Simply saying that she is not treating Karen Reed fairly, she is not treating the defense fairly, something smells fishy around here, is unfortunately not enough for this type of proceeding. However, we do have one more avenue, and that is recusals. Remember, we talked about in the beginning of the video. We can ask Auntie Bev to recuse herself. So let's talk about that next. A recusal process is very, very straightforward and is outlined codified in the legislature of each jurisdiction that you may be practicing in or not practicing in trying to remove a judge from your case. So this way, you're not removing the judge totally forever from every case that will ever happen, but you are trying to get them removed from your particular case. Okay? For instance, for those of you who have been following this channel for quite some time, I have argued and lost a recusal of a judge who refused to follow the law in my courtroom. The judge was wrong. The judge was very nasty, and I asked for us, we appealed to Chief Justice Minton in Kentucky. He is our Chief Justice in the Kentucky Supreme Court, and he denied my motion to recuse her. That was after I asked the judge for her to remove her herself, and she denied my motion. So first you appeal to the judge. You say, Your Honor, I believe you've been unfair. Please remove yourself from the case. You can imagine how often that succeeds. The judge has to literally rule on a motion for themselves to determine whether or not they have violated the rules and are unable to be fair and impartial on your case and have another judge assigned to you. You see where the ego comes in, obviously. And those motions to recuse are seldom granted by the judge in front of which that motion is, unless there truly is such an egregious conflict, financial, personal, business, or otherwise, for the judge to remove herself or himself. Another instance we have recently had success was in Levy County, Florida, with Jeremy Hales. Judge Craig Constantine Dethomasis has been asked to recuse himself not once, not twice, 3 separate times in 2024, in January, in February, and I believe there was another one at the end of February. So once in January, he denied the motion to recuse himself, and twice in February, he denied both motions to recuse himself. Now, despite that conduct, shout out to the lawyers who went to the SJC, the committee overseeing judges in Florida, and they said that Judge Dethomasis is not acting in accordance with the law. He has violated the law. He has inserted his own personal bias into the case and should be removed from this case. And guess what? The SJC removed him. As of August of last year, he was completely removed from the case and he could no longer preside over it. The judge was removed and his fellow judge, who is sitting in the other courtroom, and they alternate dates, was assigned to the case. So that's how it's done. How would it happen in the Karen Reed case with Auntie Bev? Very simply, if I recall correctly, before the first trial began, there may have been a motion that Jackson Orianetti filed requesting Auntie Bev to recuse herself. Now, I could be wrong about that, but I do remember hearing on the grapevine that that is what happened. If it didn't happen, that door is still wide open. They just need good enough reason. Because she doesn't like me and she is mean to me is not enough of a reason to get a judge to recuse herself. You need more. You need actual, open, documented bias and prejudice towards the defendant or her lawyers. So just simply her short temper, her size, etc. are insufficient for a motion to recuse to be successful. In order to get a judge to recuse herself from a case, such as Auntie Bev in the Karen Reed case, you generally need to demonstrate that there's a valid reason under the law for her to step aside. Recusal is when a judge removes herself from the presiding case, as we have said. First, you have to understand the legal standard. And in Massachusetts, the legal standard for a judge to remove herself is Massachusetts Rule 1:22, motions to recuse. It reads, any motion seeking to recuse a justice of the court from a full court case must be in writing and must comply in all respects to another rule. The motion shall be filed at or before the time for filing the moving party's brief. The court may allow the filing of a motion to recuse after the filing of the brief if the motion is based on grounds that are not known and that reasonably could have been known at the time the brief was filed, and provided that the motion is filed as soon as practicable after the alleged ground for recusal becomes known. Late filed motions are strongly discouraged. Now, this is specifically, as you can see, talking about briefs, which is probably referring to the Court of Appeals, but this can also apply to Auntie Bev. If Auntie Bev denies, or any judge denies the motion to recuse, against whom a recusal is sought, the moving party may request review of that ruling by the other justices by filing with the clerk within 7 days of the ruling a written request for a review. To facilitate this review, a justice who denies a motion to recuse is encouraged to provide a brief statement of his or her reasons for the ruling. The review shall be on all the papers and limited to the information that was before the justice whose recusal was sought, unless the court requests further information. A party requesting review shall therefore file, along with the request for the review, 8 copies, including any supporting or opposing memoranda and affidavits. See, you need evidence. You can't just say remove because she's biased. You need more. The justices reviewing the ruling will act as soon as practicable, and time permitting, they'll even hold oral argument as the case is being submitted for brief. This rule applies only to full court cases. Recusal rulings in a single justice case are and will continue to be reviewable in the regular course on appeal from any adverse final judgment in the single justice case. Nothing in this rule is intended to change the substantive law governing recusals. So next, you need to gather evidence. Like I said, simply saying, I don't like this judge and I don't like the way that she's treating me is not enough for a recusal. You need concrete reasons, like prejudiced statements made in court, which we're starting to pile on. We may be getting close to having a viable motion to recuse Auntie Bev from the Karen Reed case. If Auntie Bev has a history with one of the parties, remember the text messages between her and one of the Alberts. That's where she got her nickname, because he used it. Oh, you mean Auntie Bev? She uses the beach house periodically. So maybe she has some sort of vested interest. If you can show proof that she has visited the Alberts' house, and in that capacity, she is leaning towards being biased for the individuals who testified in the first trial, the Alberts and the McCabe's. If you can show her connection to Morrissey, just because Morrissey helped get her the position in 2008 with Governor Devil, that's insufficient. That is not enough. She would have been removed by now. 17 years on the bench is a long time. That is almost a third of her lifetime that she has spent on the bench. Maybe you can show that the judge is standing to gain something from the ruling or from a conviction in this case. If you can show that if Auntie Bev helps convict Karen Reed, she is going to earn favor, maybe not necessarily financial, but personal favor with the Alberts or the McCabe's. You can use that. Also, if you can compare it to her past rulings, how she treated other defendants in her courtroom accused of similar things, or other litigants that are not Jackson, Yannetti, Little, or Alessi. If there are any public statements that she has made about the case, which I don't think she has in this case, but maybe other cases, or any financial disclosures if they're available. Any bank statements that could show that transfer of money was coming from the Alberts or the McCabe's into Auntie Bev's bank account. It would be very difficult to retrieve, especially this early on, but that would be something that could be looked at in the future. Then, of course, once you've gathered all the evidence, you file your motion to recuse. It's a formal request of the court, just as we read in the rule, usually written by your attorney, and in this case, Ms. Little, I'm sure, would be tasked with drafting it. And it's going to outline the facts and the legal basis on why Auntie Bev can't be impartial, or any judge. Now, Bev, in this particular example, would get to decide whether or not she gets to stay on the case or not, which seems a little bizarre, don't you think? But yes, that is exactly what happens. The motion goes before her, and then she reads it and goes, yes, I should probably recuse myself from this case, or no, I am not going to recuse myself from this case. We're moving forward. Your next motion, Mr. Hanky? Whatever it is. Now, if Auntie Bev or the judge that you are asking for them to recuse themselves refuses, you have the right to appeal the denial, and it depends on the system. Courts hate recusal motions that are simply based on pure fishing expeditions. You see, here so far, we're approaching maybe something concrete, but up until now, it has been nothing more than fishing expeditions on our behalf, unfortunately. And that's why Jackson and Yannetti have not filed it yet, for obvious reasons. Just because you're maybe losing your case is not enough of a reason to remove a judge. Don't waste the court's time, is basically all I'm saying, if you're moving to remove a judge. Realistically, success is extremely rare without obvious, blatant evidence. Judges are trained to stay neutral. Easy to say when you have a judge that is so condescending and ruthless to one side and is completely innocent and nice and polite to the prosecution. But fair enough. Judges don't lightly step down, especially if you're in a small town. Everybody knows everybody. Implied bias might not be enough unless it's provable. So there are two ways to remove Auntie Bev. One, impeachment and then removal by the legislature in Massachusetts. Or two, by filing a motion to recuse, and if she denies it, appealing it, and if it gets granted by a higher court, she will have no choice but to remove herself from the case. Now, the interesting thing is, because I have personal experience with this, I can speak from experience. When you move to recuse a judge, in the moment where you file that motion, they lose jurisdiction. All proceedings are considered halted, at least in Kentucky, and I imagine in many other places. And the judge has no choice. You literally have a way to freeze proceedings at least one time with one swing of your bat. So use it very cautiously. Do not piss off the judge just because you need some extra time to file a motion or two. Filing a motion to recuse deprives the judge of jurisdiction in that moment that you file it, and they only regain jurisdiction once the higher court or the judge above them comes back and says, no, 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 it's okay, or yes, 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 you are removed, okay? So use them very sparingly, and in this case, maybe there's some more digging we have to do. I don't know. You guys know more than I do. As always, the chat is always right, and I will see you all in the next video. Bye, everybody.